Good afternoon, and thank you for joining me for today's webinar, which will cover the recent legislation passed by Parliament giving effect to the Family Law Court merger. My name is Tiela Morrison, and I'm a solicitor at Michael Lynch Family Lawyers. I've had about 3 years of experience in the field of family law, which means I've had exposure to how the court system currently operates. And now, like all family law practitioners, I'll need to adapt to how the new court system will work. Just a bit about Michael Lynch Family Lawyers before we start. As many of you would know, we're a specialist family law firm, and the firm is celebrating its 25th birthday this year, which is very exciting. The team is made up of 13 lawyers, 5 of whom are accredited family law specialists, and together we have over 100 years of professional experience in the field. We see private clients and give professional advice in all areas of family law. For new clients, we offer fixed cost and obligation-free consultations to give the clients that initial critical advice about their situation so they know how to navigate their family law matter. Before we jump into the recent news of the Family Law Court merger, I will briefly explain the history of the family system and how it has evolved over time. I will then delve into the details of the recent Family Law Court merger and how it will work. I will hopefully be able to dispel some myths and confusion that has been created from the recent media attention. For those interested in what has been said in the media, I'll provide an overview of the pros and cons that have been said about the court merger. By way of a background, I just wanted to explain the structure and development of the family court system over time. I don't want to bore you with the history lesson, so I'll try to be brief. So the Family Court of Australia was first established in 1975. And it commenced operation in 1976. The court consisted of, and still does consist of, a Chief Justice, a Deputy Justice, and other judges. The court has registries in all Australian states and territories except Western Australia. The court system in Western Australia is slightly different to those other states and territories, so I won't go into detail about Western Australia in this webinar. In 1999, the Federal Magistrates Court was created and it commenced operation in 2000. The court was created to ease the burden placed on the family court and to allow the family court to focus on the more complex family law matters. In 2013, the Federal Magistrates Court was renamed the Federal Circuit Court of Australia, and it is in existence today. The court was changed to more accurately reflect the role of the court and its accessibility for court users. The word circuit was included in the name to reflect the prominence of the court's circuit work in regional areas, and the word federal reflects the broad jurisdiction in family law and general federal law matters. General federal law matters include consumer law, bankruptcy, administration law, migration law, human rights law, just to name a few. In terms of the hierarchy of the court, the High Court of Australia is the most superior court. The Federal Court of Australia and the Family Court of Australia are aligned in their level of seniority. The Federal Circuit Court of Australia shares the jurisdiction of its superior courts. However, it has a lower status, similar to that of the state district courts. Given the Family Court is the more superior court than the Federal Circuit Court, the decisions made in the Federal Circuit Court can be appealed to the Family Court and sometimes the full court of the Family Court. A full court is where 3 judges hear the appeal together, and the group of judges are called the appeals division. Decisions made in the family court can also be appealed to the full court of the family court. In special cases, parties can apply for leave of the court to appeal a full court decision to the High Court of Australia. As there are 2 different courts dealing with family law matters, being the Family Court and the Federal Circuit Court, there are 2 different sets of legislation and court rules to follow. There are also slightly different processes, procedures, and court forms for commencing proceedings in the Family Court as opposed to the Federal Circuit Court. For example, in the Family Court, there are what are called pre-action procedures which need to be followed prior to commencing court proceedings, except in exceptional circumstances. Pre-action procedures include participating in family dispute resolution services, and if that is unsuccessful, engaging in negotiations through written correspondence. Parties are also required to, as much as possible, comply with their duty to provide full and frank disclosure of their financial circumstances before commencing court proceedings. Pre-action procedures assist parties to resolve their disputes quickly and ideally without legal action. Otherwise, the pre-action procedures assist parties to identify the legal issues in dispute to be determined by the court. Generally, where parties have been unsure about which court to file their application in, it has been best practice to file the application in the Federal Circuit Court and let the court determine if the matter should be transferred to the Family Court. Often in practice, however, solicitors tend to file their client's application in the Family Court, even where the matter may be less complex, so that the matter can be processed more quickly in the Family Court than it would in the Federal Circuit Court. This, however, has become a problem and is clogging up the Family Court a bit. While there have been 2 courts hearing family law matters, the courts apply the same legislation to the matter to reach outcomes. I mentioned earlier that since the Federal Magistrates Court was introduced, the Family Court has heard more complex matters and less complex matters have been allocated to the Federal Circuit Court. Just so that you're aware, in parenting matters, the more complex cases involve ones where there are allegations of sexual abuse or physical assault of a child, family violence or mental health issues with other complexities, where there are multiple parties, or where there's international child abduction under the Hague Convention, just to name a few. In terms of property settlement matters, complex cases involve financial cases where there are multiple parties, valuations of complex interests in trusts or corporate structures, and like parenting matters, where there are complex questions of law and special jurisdictional issues, or where there are various expert witnesses required at the hearing. Matters which are complex in nature also generally require more than 4 days for a final hearing. Family law disputes which have been determined to be less complex and heard by the Federal Circuit Court include the general parenting and financial cases, child support and maintenance issues, divorce matters, injunctions, contravention applications, and location and recovery of children. Given that most matters before the court are generally less complex in nature, the Federal Circuit Court hears a higher number of matters than the Family Court of Australia. Currently, the Federal Circuit Court hears approximately 90% of all family law matters, and 92% of all parenting matters. While we appreciate the specialist nature of our family law court system, it is far from perfect. The increasing number of separated and divorced parties over the years seeking the assistance of the court has meant that parties need to wait longer periods of time for a judge in the Federal Circuit Court or Family Court to hear their contested hearing. In the Federal Circuit Court, the current waiting time is approximately 12 months to 2 years. The issue causing the backlog has said to have been funding problems and lack of resources. The delay has meant that the parties have spent significant costs on legal fees in preparing for and attending final hearings. We, of course, always recommend that parties try to resolve their dispute through alternative dispute resolution mechanisms such as mediation prior to commencing court proceedings or prior to proceeding to a final hearing. However, this is not always possible. In parenting matters, it's compulsory for parties to participate in family dispute resolution prior to commencing court proceedings anyway, except in exceptional circumstances. After the final hearing, the judge needs to release their decision. Oftentimes this takes several months. However, I have heard where judges have taken around 6 to 7 years to release their decision. This creates further delay, and oftentimes parties apply to set aside that order, given that there's been a significant change in circumstances over the years prior to the decision being released. To throw a spanner in the works and attempts to fix the problems with our court system, Parliament has now decided to change the well-established family law court system. On the 17th of February this year, the Senate met in Parliament and passed what is called the Federal Circuit and Family Court of Australia Bill of 2019 and its supplementary legislation. The bill only narrowly passed, with 30 votes for the bill and 28 votes against it. The laws that were passed effectively mean that the Federal Circuit Court and the Family Court of Australia will merge together to create a new court called the Federal Circuit and Family Court of Australia. The change has been initiated due to the significant delays, additional costs, and unequal experiences, as well as the confusion and inefficiencies for many families associated with the two different courts. The change to the court system has been speculated for a few years, with the Morrison government first introducing the reforms in August of 2018. The legislation lapsed due to the closing of Parliament for the 2019 federal election. However, a new version of the bill was created after parliamentary review. The bill was then passed by the lower house of Parliament in December of 2020 and then considered by the Senate in Parliament last month unexpectedly. So how will the new Family Law Court merger work? The new Federal Circuit and Family Court of Australia will be divided into two divisions. Division 1 will hear matters previously heard by the Family Court, which are the more complex family law matters, and it will comprise the judges that are currently in the Family Court. Division 2 will hear matters previously heard by the Federal Circuit Court, which are the less complex matters, and it will comprise the judges currently in the Federal Circuit Court. Currently, there are 33 judges in the Family Court and 40 specialist judges dealing exclusively with family law matters in the Federal Circuit Court. The new court will operate under the leadership of a Chief Justice and a Deputy Justice, both having dual commission to deal with matters in both divisions. Judicial appointment criteria. Newly appointed judges will need to satisfy certain criteria in relation to knowledge, skill, experience, and aptitude to ensure they are able to deal with both family law and federal law matters. By August, it is intended that there will be 35 specialist judges in Division 1 of the new court and 43 specialist judges in Division 2 of the new court. The legislation prescribes that the number of judges in Division 1 cannot be lower than 25, and that retiring judges will be replaced. Division 1 of the new court will deal with family law matters only. However, Division 2 will deal with family law and general federal law matters. In the current system, there are judges in the Federal Circuit Court who deal exclusively with family law matters, and there are judges who deal with federal law matters. The new court will see judges deal with both family law and federal law matters together, which is of great concern to various stakeholders who oppose the legislation. In the new court, there will be a single federal point of entry for all Australian family law matters. All family law matters will be commenced in Division 2 of the new court. The matters will be subject to a case management approach run by judges and registrars of the court. Urgent and high-risk matters will continue to be prioritised. All cases will be allocated at the earliest possible point to the most appropriate judge in the most appropriate division. Once allocated to the most appropriate division, the matter will not be able to be transferred between divisions without the Chief Justice doing so. In deciding whether to transfer a matter between divisions, the Chief Justice will need to have regard to whether there is an associated matter pending in Division 1, whether Division 1 has the resources to hear the matter, and the interests of the administration of justice. Once a decision has been made to transfer a matter to a different division or not, there is no right of appeal for this particular decision. New court will mean that there will be ultimately a common set of rules, procedures, practices, and approach to case management. The legislation provides that for the first 2 years, the rules will be determined by the Chief Justice and Chief Judge. After this initial period, rules will be determined by all Federal Circuit and Family Court judges. There are also likely to be changes to procedures in terms of the court forms to use to commence proceedings in Division 2. It is also intended that the new system will streamline the family law appeals pathway. The current appeals division of the Family Court, which is the full court of the Family Court, which hears appeals from the Family Court and sometimes the Federal Circuit Court, will be dissolved. All new Federal Circuit and Family Court judges will be able to hear appeals if they're in Division 1. They will be able to hear the appeals as single judges or as a part of a full court. All appeals from Division 2 and from the Family Law Magistrates Court of Western Australia will be heard by a single judge in Division 1, unless the Chief Justice determines it appropriate for the matter to be heard by a full court. This is aimed at reducing the backlog in first instance family law matters and to allow the new court to hear a higher number of cases each year. The announcement of the merger has no immediate impact on matters currently before the Federal Circuit or Family Court of Australia, including matters in the COVID-19 list or the Lighthouse Project, which is a screening mechanism used to identify cases involving risk or family violence. It has been said that transitional arrangements will be put in place so as to minimise any delay or inconvenience to parties still before the court when the merger is to commence. It is important to note that the law itself to be applied to all family law matters has not changed, only the mechanics of how the court will operate. The law to be applied still remains as the Commonwealth legislation called the Family Law Act of 1975. Geographically, the new court will be located in the same place as where the Federal Circuit Court and Family Court of Australia are currently located in each area. In Brisbane, that is on the corner of North Quay and Tank Street in Brisbane City. It's important to note that the new court is different to the state courts, including the Magistrates, District and Supreme Courts, which are located in George Street in Brisbane. As I mentioned earlier, there have been many views expressed about the new family law court merger. Opinions have been expressed by various family court judges, associations within the family law community, as well as other professions dealing with Australian families. The Attorney General has asserted that the changes to the court system are aimed at reducing the costs and delays experienced by Australian families with the split federal and family law court system. He also says that the new court will improve the user experience for Australian families. Those for the merger have agreed and said that the new system will help Australian families resolve their disputes faster by improving efficiency, reducing costs, and driving faster, cheaper, and more consistent resolutions. However, there have been many criticisms of the new court merger. As of November 2019, there were officially 155 stakeholders who opposed the bill, which included 13 retired court judges who wrote an open letter to the Attorney General expressing their concerns. The group emphasised their concern that the new court system would have a devastating impact on families. The system would result in a loss of structure, systemic specialisation, and it would dismantle the appeals division. Amongst the stakeholders who signed the letter was former Chief Justice of the Family Court, Elizabeth Evatt. Ms. Evatt has said that the increasing number of cases in which issues of family violence and child abuse are raised has led to an even greater need today for family law jurisdiction to be vested exclusively in judges who are specialised and can give their full attention to the needs of family law clients without being diverted to exercise unrelated jurisdictions. Ms. Evatt says the new system goes against this principle and is not in the public interest. One of the concerns voiced by many stakeholders is the impact on the merger on family law matters involving violence. They say that the victims of family law violence may fall through the cracks. The Attorney General has, however, said that while there are concerns about judicial officers being appointed and needing the skills and experience to deal with family law matters, the new system and the bill provides for this to occur. The Chief Justice of the Family Court and Chief Judge of the Federal Circuit Court has recently released a statement saying that the court has consistently denied to comment on the new merger and said that the court's role is to apply the laws of Australia to decide decisions and to interpret the laws of Parliament. He said that the new court will continue to have a statutory obligation to have regard to the need to protect the children and promote their welfare and protect them from family violence. The Chief Justice also recently said that the courts will continue to seek further resources from the government to implement these important new reforms and other measures so as to reduce the delay and chronic backlogs. The Chief Justice is of the view that with change comes opportunity, and he asks that we all work together to create a world-leading family law system. So despite the negative views of various stakeholders, which may include many of you listening today, we as family law practitioners need to adapt to the new court system, which is likely to take effect on the 1st of September this year. And we need to try and navigate our way through the new court system. We hope that the new court will be an improvement on what has come to be a delayed and costly court system, but we will have to wait and see. We intend to keep all of you up to date on any developments around the new court merger as they arise. Thank you again for joining me this afternoon for this timely webinar. We thought now was a great opportunity to explain the news of the family court merger and answer any questions that you may have had after hearing the news through the media. If you have any specific questions around the family court merger or what I have raised today, please contact our office by using the details on your screen. After the webinar, we will send around a feedback survey which you can use to specify any specific questions or comments you have about today's webinar. We really appreciate any feedback that you have. But if you'd like to know more about specific family law matters, we have past webinars on our website. They cover a range of topics, including property settlement, parenting matters and children, relocation issues, and specific webinars for counsellors and accountants. We also have other helpful resources on our website, including articles and other publications, which I'm sure will be of help to you and your clients. We also have another upcoming webinar on the 21st of April in relation to grandparents in the family law sphere. I'm sure it will be very informative for you and your clients. If you have any suggestions about topics that you would like to see covered in future webinars, please let us know. Otherwise, as always, if you have clients who have gone through a separation or marriage breakdown and they would like some specialist family law advice, we are more than happy to assist. Again, we offer initial obligation-free consultations for all new clients. Thank you again for joining me today, and I hope you've enjoyed the webinar.